And so we before we were set to speak to Keith Darian, who is in charge of financial investigations at the FID, the Financial Investigations Development. Beg your pardon, Courtney Smith from the FID. Before we do that, there's a matter that came in the news on, well, it happened on Thursday, and the excellent court reporter from The Observer, Alicia Dunkley Willis, senior reporter, she did a story on it, and I read it early this morning, and I found it to be very revealing in terms of the thinking of the judge and her interpretation of the matter at hand. What I'm talking about is that Observer story concerning the former president of the Jamaica Teachers Association, LaSonia Harrison, and her bid to have the Supreme Court nullify the March 2023 agreement signed by the union accepting the government's wage offer of a 20% minimum increase in basic salary after tax. Now, LaSonia Harrison, when Mark Malaver's term ends, will be the next JTA president. So she served, stepped away, 2 JTA presidents in between, because before Mark Malaver it was Dr. Mark Smith from
Correct.
Monroe College, the principal there, outstanding man. So from Dr. Mark Smith to Mark Malaver, and then we're going to go back to LaSonia Harrison again. Now, for context, when that agreement was signed by the JTA, well, when the vote was taken and organized, when the vote was organized and taken among JTA members, LaSonia Harrison was the president of the Jamaica Teachers Association. And it is after she stepped away from the role as president and with other things. Oh, I'm being told by my producer that not only did the vote that she brought to court was organized when she was JTA president, and that the vote happened when she was JTA president. I'm being told that she chaired the meeting
where the vote
was taken. And then after all that, she went and she applied to the court to have all of that thrown out. And I'll tell you on what basis. You have the article there? Well, let me strike on.
Mm-hmm.
Alicia Dunkley Willis writes in The Observer, and I think it's important for the listeners to hear this. Harrison, who served as JTA president for 2022 to 2023 and who has since been re-elected for a new term set to begin this year, filed a claim in the Supreme Court last July challenging the validity of the special general meeting held in March 2023 during which the agreement was signed. My note is she's challenging the validity of a meeting that was organized under her leadership, that was held under her leadership and which she chaired. Back to the article. She argued that the meeting was not convened in accordance with the Articles of Association of the JTA, making the agreement therefore null and void and of no legal effect. My note. She went to the court to argue that the meeting that she convened, the meeting that she presided over, she argued that that meeting was not convened in accordance with the Articles of Association of the JTA, making the agreement of accepting the 20% minimum increase in basic salary after tax. That agreement was therefore null and void and of no legal effect. The article continues. The veteran educator, who is also principal of St. Faith's Primary School in St. Catherine, sought several declarations from the court, including that the purported special conference was unlawful in that the vote that took place at said conference was not in keeping with the constitution of the JTA. My note, she told the court that this conference that she organized, attended, and chaired, that conference was unlawful in that the vote that took place at the conference that she organized, attended, and chaired was not in keeping with the constitution of the JTA. Back to the article. Alicia Willis Dunkley Willis writes, a total of 776 people participated in that special conference, which was held virtually on March 12, 2023. Of that number, 629 of the 776 voted to accept the ministry's offer. 147 of the 776 voted to reject it. Based on the majority vote of the delegates, the government's proposal was accepted and the signing was done on March 13, 2023. Now, this is the point at which the fly fell into the ointment, because the article says Harrison did not sign the proposal. Instead, it was signed by the president-elect at the time. The article continues. She further sought a declaration from the court that the constitution of the JTA does not provide for a special meeting to be conducted online. It was an online meeting, as well as a further declaration that the online voting that was done on March 12, 2023 was unlawful, null and void, and of no effect, in that the delegates did not vote in keeping with Section 14 of the Constitution of the JTA. Harrison, the article continues, who was represented by attorney Hugh Wildman, further sought to have the tribunal declare that, under the Constitution of the JTA, any special conference convened must be held with the physical presence of all delegates who participated in the vote, and not by virtual voting, and a declaration that under the Constitution of the JTA, there is no provision for a virtual conference to be convened as a form of special conference pursuant to Section 14 of the Constitution of the JTA. My note, remember, all of the things she's now saying and all of the things she told the court was wrong with the conference, and why the conference shouldn't have been held, and why therefore any decision taken at the conference was null and void and of no effect. She was the one who organized said conference, who attended said conference in the role as chairman, played the role of chairman. She was central to the same conference she was now said had several flaws. She was now saying had several flaws. Let me take the break and come back and tell you what the judge said in responding to the applications that LaSonia Harrison made. Welcome back to Nationwide this morning. Reading for you because it is so important. Yeah? A story published in the Jamaica Observer, written by senior reporter. She's very, very good in the court, Alicia Dunkley Willis. And she is chronicling what happened in the case brought to the court by LaSonia Harrison, former JTA president. Effectively, when Mrs. Harrison was president 2022 to 2023, JTA members convened online for a vote on whether to accept a 20% minimum increase in salary after tax from the government. They voted to accept the proposal. Mrs. Harrison, who organized the meeting as JTA president, who saw to it that the meeting was executed as JTA president, who chaired the meeting, then applied to the court to say the meeting wasn't properly convened. The issues, therefore, that the meeting agreed on were of no effect, null and void, and therefore of no effect. And she was asking the court to assert her findings. In her evidence presented to the court, I'm continuing with the article, Harrison argued that she had a duty to ensure that what was done at the special conference was in keeping with the JTA's constitution. To that end, she said she sought and obtained legal advice, and based on the advice she received, she concluded that the voting was not done in keeping with Section 14 of the JTA Constitution, which mandates that all voting at a special conference must be done in the physical presence of all the delegates. She contended that since the special conference did not conform to Sections 13 and 14 of the Constitution, the vote taken at that special conference was unlawful, null and void, and of no effect, meaning that the salary package which was accepted by delegates and given to the members is void, as the JTA was not properly constituted in carrying out the vote to accept the government's offer. All right, you must be asking now, listeners, so what did the judge say, Judge? Here is what the judge says now. Supreme Court Judge Justice Tania Mott Tolo-Reid, in assessing whether Harrison was in the first place even the proper person to bring the claim, said, quote, if the majority of the members were of the view that the salary package offered by the Ministry of Finance was a reasonable one, this court is unable to comprehend the basis on which this claim is being made by a sole member acting on her own initiative with no instructions from the group of which she's a part. The quote from Justice Tania Mott Tolo-Reid continues. It is also to be noted that the claimant in bringing this claim is not acting in a representative capacity. She makes the claim on her own behalf and seeks relief on her own behalf. Her affidavit is sworn on her own behalf as a member of the defendant and an immediate past president. There is nothing in her evidence which suggests to this court that the remedies she seeks are being sought on behalf of the membership as a whole, although it is clear that any decision made will affect the membership as a whole, Justice Tolleride said. Now, in dismissing Harrison's arguments, Justice Tolleride said, quote, "The meeting at which the decision was taken to accept the counteroffer proposed by the Ministry of Finance, which was done virtually and which vote was taken by a show of hands virtually in 2023, was in accordance with the resolutions passed in 2021 and in keeping with the amendments to the Companies Act also passed in 2021. In refusing the orders sought by Harrison, Justice Tolleride, in the ruling handed down on January 19, said, quote, "I am of the view that the defendant, which is the JTA, was authorized by its own constitution to accept the wage package that was offered by the government of Jamaica. My orders are therefore as follows. The orders sought by LaSonia Harrison in the fixed date claim form filed on July 10, 2024 are refused. LaSonia Harrison is to pay the Jamaica Teachers Association costs in the claim, which are to be taxed if not agreed, and she should pay the lawyers used by the Jamaica Teachers Association and serve the judgment." Attorneys Caroline Hay, King's Counsel Caroline Hay, and Zuri Johnson, instructed by Hay McDowell Attorneys at Law, they represented the Jamaica Teachers Association. Justice Tolleride, good morning to you, ma'am. And I see good sense prevailing in this matter, Tana Thomas.